Good evening to everybody. Welcome to this today's webinar on evidence in civil trial. This webinar is conducted by Legal Scholar Academy, which we conduct it on every Friday at 7:30 p.m. on different topics. So today's topic is, as I told you, is on civil evidence law in civil trial. So welcome you everyone. So I appreciate all of you attending this webinar, taking out your time, and it really shows that you are equally keen to increase your knowledge, because way in which our profession goes is that the more knowledge, more experience you get, more you know about it. And evidence law is such a complex topic. Evidence law is such a complex topic. I recollect, I don't want to name anyone, in one of the trial matter in the High Court. It was a trial matter in the special court. Special court, I don't know how many of you remember that Harshad Mehta scam in that special court matter. And that time I was quite junior, means I think just around 2 years old or something in the practice. So I was requesting for the judge to keep back the matter, or rather defer the cross-examination for our turn. So one very eminent senior advocate, very eminent, let me tell you. That time he told, when I was requesting, let's just see the context. He told that even after 50 years of practice, I have to still refer to the evidence law. So you can understand how complex or difficult it is. And now, particularly after many things have changed, what it was 20 years, 15 years back has changed now because of introduction of digital evidence and all these things. So with this, I'm welcoming you all once again. What I'm requesting you all is that, can you all put in your chat box your name also? So what happens is that many of the judgment which we circulate, I want to really keep it very strictly only those people who are sincerely wants to attend it. Some people request me that for XYZ reason they are not able to attend, then I have to give it. It is not something like it's my portfolio that only I can have it. But what I do is that, and I will suggest every one of you to do that, more or less, I see website of High Court, website of Supreme Court daily, more or less daily, and see what are the relevant judgment which I feel I should keep it with me. And with the experience, within 2-3 minutes, we understand what is the topic of, and if it is of topic of interest, then I put it in my library. Otherwise, I just leave. So you also put that habit of storing those judgment. Not necessarily it's possible to read it. Let me tell you, not possible to read it. But at least you understand that there is a judgment on this point. As and when the issue comes, you will be able to see it. That's the reason I'm telling all of you, follow that practice with whatever you are doing in that store. Make your own a library bank, and I think my present library bank is, I think, more than 10 GB or 15 GB. 10 GB means it's a huge when you call about document. Just over. Yes, request all of you to keep yourself muted. Yeah. So continue. Our today's topic is evidence in civil law. See, when Rakesh, just see who it is. All are muted, but some voice is coming here. Okay. Okay, Rakesh, I think I have not made you host. Yeah. You are all able to hear me out. Sorry, I didn't ask it. If you can hear me out, just tell me, type yes, YES in the chat box. Yes. 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 So when we talk about evidence law, many times it used to come when we started our practice. The Evidence Act is only applicable to the criminal law. And you will find many of those telling the same thing. That evidence is applicable only to civil criminal law. It's not that. Evidence law is equally applicable, rather it's more complex when it comes to the civil law. Because one way if you see it, it's easy. If you see another way, someone knowing it properly can create a multiple problem for you when you are leading a evidence. Now it is comparatively easy. I will just briefly taking you through the way how the trial goes on in the civil law. Comparatively easy because now we are permitted to file an affidavit of evidence of a witness. So it's comparatively easy. See, if you see, its examination of the witness is comparatively more difficult than if you see the comparatively examination of or cross examination of the witness. Because at least in a cross examination,
ठीक
you
है
can
ठीक है ठीक
demolish him. Okay. Just request everyone to just mute yourself because I have put it in the mute here. I have put in the security as mute, but because this Zoom application is through some other application, so it becomes difficult to control. Okay. Now coming to the evidence part. So before that, let's just first understand what is the process for civil trial. I will just briefly take you through that. Everyone can see this procedure in civil trial, right? This is just rough I am it is not something in detail in depth. So basically when we talk about a civil case, a civil procedure case, civil case, it starts with filing of a plaint, filing of a suit, what we saw sometime called, by presentation of the plaint. So once plaint is presented, depending upon code to code how it works, now it is all online, many of the things. So first part is presentation of the plaint. You file a suit for by presenting a plaint. There are a lot of issue on what is the presentation of the plaint. Whether it's what is the filing of the suit, not presentation. What is the filing of the suit? Whether the filing of the suit, whether it's the day you present it or the day it is marked as accepted. I'm not going into that. So that is the first part which comes. The second part comes is that technically is that then a summons has to be served to the defendant. Then defendant files a written statement. I'm just again repeating it. I'm just going roughly through it so that we come to our topic. First suit is filed, that is a plaint. Then the defendant files a written statement. Thereafter, framing of issue. For our purpose, framing of issue is most important part for our discussion today. What is framing of issue? Framing of issue is nothing but recording something that what is the differences of the party. Means what are the issues? Means what is the difference? Suppose just to give an example, if it is suit for specific performance of the agreement, plaintiff says that there is an agreement between him, plaintiff and defendant of XYZ date. And defendant denies that. He says there is no such agreement. So the issue will be that. So there is a difference. Means plaintiff is says that there is an agreement. So defendant says that there is no such agreement. So there will be first issue will be there. Does plaintiff proves that just plaintiff proves that there is an agreement between plaintiff and defendant dated so and so. So where there is a difference, so that is an issue. So that framing of issue is supposed to be actually done by the court. But in normal practice, what happens is that both the parties, both the advocates, sometimes depending upon which court you are, how the judge is, it's all relative term. Both the parties sometimes forward their draft issue to the court, then so court settles it. Otherwise, sometimes advocates sit together and they finalize the draft, agree it, and give it to the court. Some court also I have seen is that though they insist, no, we are going to draft our own issue. That also I have seen. So this is how the issues are framed. When issues are framed, in that there will be clearly stated who has to prove what, means whom the burden lies. Just extending the example which I gave, the example which I gave in this, the defendant is denying that there was a agreement between between plaintiff and defendant. So the burden is on the plaintiff to prove that there is an agreement. So burden is on the plaintiff. So issue will be, does plaintiff prove that there was an agreement between plaintiff and defendant dated so and so. So that is the first issue. Suppose I just make some difference to that, the given example. The defendant is accepting there was an agreement, but he is denying that he has received any consideration. So then the issue will be, does plaintiff proves XYZ amount was paid by him? So it will depend from the case to case basis how the issues are and whom the burden lies. We'll come to that when we take certain example, when we try and take this example that time. Okay. So once issues are framed, then part comes of evidence. Now things are made simple comparatively because we have a process of filing of affidavit of examination in chief. What is the process? Means what? How should be the affidavit of examination in chief? I think Justice Patel, as in one of the judgment, I will share with you, all of you, has very categorically stated how the affidavit should be. Let me tell you how. I will just give an example. See, basically, when we are drafting an affidavit of examination in chief, it should be something like that. A person enters into a witness box, and what is he going to tell the court? He will tell the court that there was an just I'm extending that same example I'm doing. He will tell the court, suppose he is in the witness box, that this and this agreement was entered between him and defendant. This is the original agreement which I am producing it. This is my signature. The another signature is of defendant. See, mark my word what I am telling you. The another signature is of defendant. It was signed in my presence. And if there are witnesses to that agreement, then he will also tell there are two XYZ witnesses. So this is what he is expected to tell when he is in a witness box. And sometimes if witness is not intelligent, let me tell you, it used to be hell of time to even do this simple thing in the witness box. But fortunately now, all of us, it's not that difficult. But then what used to happen is that the affidavit used to be like the affidavit in support of application or notice of motion in the High Court, what we say. It used to be like that. There used to be legal submission, there used to be many other things which are not there. So affidavit has to, when you are filing, has to be like someone getting into witness box and then is putting that this is a document. Then if I will come again to those, when if there is you are putting a secondary evidence, then you have to make out a case in that for secondary evidence also. Secondary evidence and primary evidence also I will be taking it now. So in that also you have to put a foundation depending upon how what it is. Also foundation is possible for secondary evidence. Now the first part, when we are talking about, is marking of the evidence. Marking of the evidence as exhibit. What does exhibit means? Exhibit means basically a document is proved. When we are talking about document is proved means it could be proving of existence of document. Take my word, existence of document means, take an example. Suppose I write or other plaintiff writes some letter to B. He has produced that document by with his affidavit. So what is proving is that the existence of that a letter which he has given to B. That doesn't mean you are proving content of the document. In that document, in the letter, he might have stated it was done, I have given you this money, I have done this XYZ. That will only again prove that there is a letter which he has given to B. Means plaintiff has given to defendant. But again, he has proved there is the existence of document, but it will not amount to the content of document being proved. It will all depend on what is there in that document, what is written, what else corroborative evidence you are giving to whatever is stated in the document. So this is a brief. First step is presentation, filing of plaint, then written statement, then framing of issue, then proving it by of evidence. Thereafter, next step is argument by respective party and judgment or decree of the court. That is how the whole trial court functions. Nowadays it's more difficult because I remember when I was more in the High Court original side, hardly any trial used to be takes place, and I think the situation is not different even now also. So you have to be fortunate enough to get a trial. At least nowadays we do a lot in the arbitration, the trial of examination and cross examination. Though technically speaking, Evidence Act is not applicable to the arbitration. Please mark my word, Evidence Act very clearly states that Evidence Act is not applicable to the two things. One is Arbitration Act and also an affidavit. Okay. So any question on whatever is discussed up to now so that I can proceed further? If no, type no in the chat box so that I can proceed further. Okay. So now, when we are talking about evidence could be of oral and evidence can be documentary. So when we are talking about oral evidence can be of something which is heard, which is seen, which is perceived. Primarily, this is what is oral evidence. Other also I will come. Basically, these are oral evidence. Then the rest of all are documentary evidence, which will also cover even CD if you have to go, video you have to go. All those things will come into the documentary evidence. So now, when it comes to the oral evidence, let's see what does the law says about that. Sorry, I forgot to tell. When we are talking about evidence, it's Indian Evidence Act 1872, which is the Evidence Act which is applicable, which I think I didn't tell you. So now let's see it. Again, I'm repeating, I'm just suggesting you something, you go more deeper into that, so that I'm just putting into your mind certain things. Check up when I'm saying that affidavit, it is not applicable to affidavit, it is not applicable to arbitration. So you check up where it states in that act. Just I'm just giving you a thought process so that your thought process starts running. Okay. So now when we comes to the oral evidence. So now oral evidence means basically has to be something which is orally you are telling. Basically, when a person enters into witness box, if it is had been otherwise, I mean to say, if not by affidavit, basically is telling orally X, Y, Z. So what is that oral evidence? It is called oral evidence. Though you will give it by affidavit, but it is a oral evidence. So then when we speak about oral evidence, then what does law says on the oral evidence? Sorry, I didn't write the particular section. Oral evidence has to be direct. Direct means what? If a person has seen it, the person who has seen it should enter into witness box and tell he has seen XYZ happening. Particularly when it comes to a criminal matter, the person who has seen something happening on the place, he is the only person who is competent to give the evidence. Sorry, now coming to this topic. Who is competent to give witness? Nothing. Any person who understands what's happening is a competent to give evidence. So there is nothing defined that he is to be major, minor. There is nothing defined. Any person can be competent to give evidence, but there are certain distinction which is made when it comes to criminal law and civil law. I will come to that. Interested person and all those things. I will come to that also. Maybe not today's section on this thing. So basically, who has seen it, when it comes to if he's telling about something which he has seen, the person who has seen it only can be a competent witness, no other one. Similarly, when we are talking about someone hearing it, the person who hears it only can be the competent witness. Again, third part is perceived. You have perceived something by sense, by touching, by it could be perceive. You can perceive basically one is touch, other is smell. That's what I can see. Or taste also. So if you are talking something which has been you have been perceived, the person who has perceived it, who has tasted, who has smelled, so or who has experienced the touch, that person who has experienced it should be the person who is competent witness for that purpose. Then, if we are talking about some opinion a particular person is giving, then the person who is giving an opinion, it has to be he himself has to give it. To give an example of it, in land acquisition cases, an expert opinion like architect or valuer is put into evidence. Often it is a valuer, architect who is a valuer who goes into the witness. So when he gives a valuation report, he himself has to enter into witness box. I just again repeating from just for sake of clarification, entering into witness box means same thing like giving an affidavit, and of course he will be subject to cross examination. Yeah, now coming back to that. So when we are talking about a valuation report, he comes there as an expert, a opinion he gives of this area property XYZ is a price XYZ. So he is giving his opinion, and depending upon case to case basis, it will be based on something like valuation report, like publication of certain books, maybe of the ready reckoner. So all those things. So if he is relying upon something else, so he will also have to produce that or give that copies also. So it's an opinion which is given if it is based on certain ground, on certain, if it is on based on certain treaties. Again here I'm just again interfering. It could be also possible when you are telling that your opinion on based on certain things. So what is a certain thing could be, if your opinion is something on Newton's law of gravitation or Einstein theory, you don't expect Einstein to bring into witness box. But if it is not something what popular or settled law, maybe in that case again it could be a controversial also. Then maybe you will have to get that person who has given that opinion or who's on basis of what it is given. So it is again subject matter on how the things goes along. Now sometime I see particularly it happens, husband and wife, some transaction just for sake of doing it, it is done in the name of wife, and just the example which I gave, suppose the agreement is entered between a lady who is person's wife, and then since he gives agreement is between you, so she is a plaintiff, but all transactions are done by the husband. So technically you will find invariably she gives a power of attorney to her husband. Plaint is also signed by the husband only as a constituted attorney of his wife. So now my question to all of you is that whether husband is a competent witness, number one, can he enter as a power of attorney holder and give an evidence in a witness box. Please take your time, a minute or two, and reply it in a chat box. My simple query is whether husband is a competent witness to give an evidence on behalf of. See, again, I am repeating, no one is right, no one is wrong in this forum. Let me tell you, I could be wrong, you could be also correct. Your experience might be different, my experience might be different. So, if someone says doesn't mean he is wrong, because even high court high court judgments are overturned by the Supreme Court. Does that mean that high court judge doesn't understand the law? Nothing like that. So please keep it in mind. Nothing is wrong, nothing is right. Everything is open. But I want all of you to take an active part so that I understand whether you are listening to me. Okay, no one seems to want to take any side, yes or no. Only two people I can say, two, three. Yes. So what I told you that basically husband is who? He was the person. He is the person who has done all the transaction. There would be certain thing in evidence which he is personally aware of it. And rest of the thing are based on a document. But here again understand this. When he is entering into a witness box, he is not entering into witness box. Technically, if you see minutely, he is not entering into a witness box as a constituted attorney. He is technically, if you see, if that affidavit is drafted properly, you will have to say in that affidavit that I was the person who is acting on behalf of my wife. All transaction was done by me. So all those things, how he is directly aware of all the things, he will have to put it into his evidence. You cannot give power of attorney to give someone a evidence, someone else to give a evidence, except let there will be exception as a company authorizing someone to give a evidence, because those are on basis of certain document. So again, you depend how you are going to draft those affidavit. He will have to say that I collected this evidence from XYZ book, this book I am producing, and all those things. So when a husband, in a given example, is giving a evidence, the evidence is not is a direct evidence. Please note, if it is saying as getting inside in the witness box as a constituted attorney, you cannot give a constituted attorney cannot give evidence, and that will evidentiary will have no value, zero value, because it is not a direct evidence. Now, what I told is that in a suit, the example which I give is the husband enters into the witness box, right? How many of you know that? If you know, type yes. That in any suit, before leading the evidence, I don't want to ask this question. How many of you know? So need not worry. Always in a suit, before leading any other evidence, the plaintiff, if he desired to enter into witness box, he should be the first witness who should be entering into witness box. Unless with the permission of the court, he thought that he will enter into witness box later. So to just inform you, just tell you that when it comes to a civil trial or the suit, the plaintiff who is there will have to enter into witness box. Otherwise, plaintiff will be prevented later on to enter into witness box. If my recollection is not wrong, I think it is Order 18, Rule 3A. It's just my recollection because just while speaking now, it just clicked into my mind. But I think I am correct. My recollection is right. Probably you check up. It's Order 18, Rule 3A. Okay. Now coming to that example which I gave was about the husband entering into witness box. So basically, he is not a constituted attorney. He is giving, in all probability, a direct evidence of what has happened because might have happened in front of him. Now, further. Okay, sorry. Now, this is what this thing is because I didn't get time to go. So, but let me stop here. Now, so now we spoke about. Now I'm going to speak more because thing is that I was not able to make slide due to something keep coming. So I was not able to make slides. Okay. Now I will speak about the documentary evidence. When we talk about, now there was oral evidence. Now we'll talk about documentary evidence and then how the document requires to be full. First is that what is document is stated in the section 2 of the section. Just 1 minute. Yeah. Section 2, it says what is a document is stated. When we are talking about a documentary evidence, and particularly in a civil court, it's a documentary evidence which is of more important or rather important. And you will see invariably it's a document which you have to prove and its contents you have to prove. When it is documentary, you have to always rely upon primary document. There are primary and secondary. Primary evidence and secondary evidence. When we are talking about primary evidence means it's the original document. Understand that original document is a primary evidence. So when I spoke about agreement for sale, you should produce original document. If for some reason then there is called something secondary evidence, which is defined. There is something called secondary evidence. When we are talking about secondary evidence, is basically means you don't have original document. Just take an example. I am just putting you don't have original document, but you might be having a photocopy. You might be having a certified copy if it's a registered document. These are all secondary evidence. Similarly to the letter also. I'm just giving a random example. So those are secondary evidence. So first, what you have to do is that primary evidence has to be produced. Secondary evidence will not be acceptable unless without a leave, without a permission of the court. When we are talking, is first is primary. So what is primary documents is original document itself. I am relying more talking on the document. This thing is a document itself. Then suppose for some reason you are not having a document, the primary document is original document. In that case, in that case, you will have to rely on secondary evidence. Now, question comes, what is secondary evidence? Secondary evidence could be that it's a photocopy, normally photocopy or a certified copy. Photocopy is the not a word which is used in the Evidence Act. The word used evidence in the Evidence Act is, just let me read it for you. Word evidence, anything, a copy is made from the original by any mechanical process. Please note that this act is of 1872. And really, even now, of course, with the times, they have changed many things. But still, the word certain thing, they have retained it. So basically, yeah, basically, basically, secondary evidence means something which is made out of original. Now, so there is two things. So there was an original document was there. So today, what you are basically telling is that I don't have, you are not having original document. So you want to rely upon a secondary evidence. Now, when you want to rely upon secondary evidence, in that case, first you will have to make out a case, get a permission from the court to produce secondary evidence. So now, what is the process? Suppose in a given example which I spoke about, that let's take an example of letter. I issued a letter, plaintiff issued a letter to the defendant, right? So where is the letter today? Plaintiff is in the witness box. Where is the letter? This is often happens, sir. Let me tell. This is often happen, and advocates many of time just take it as granted. They rely on the office copy. Can you tell where is the original now? When I am issuing a letter. Let's take an example. I am issuing a letter on behalf of my client to the defendant. So where is the original letter? Right. So original letter is defendant with the defendant. What the law says? Law says you have to give primary document. So, but I can't give it. Right, Prajakta? I can't give that document. So what I'm going to do? What I was supposed to do? So what I am going to do is that I have to produce the photocopy which I have. I produce that photocopy. My question to you, all of you, is that procedure proper? I give a produce a photocopy of it. Is that procedure proper? Because original is with the defendant. So my question to all of you are there, is the procedure proper? Please take active part. Again, I am taking no right, no wrong. I know I'm writing, I'm asking certain question intentionally so that you go with taking something from me. Of course, it is not Shaolin secret. That is a law. See, this is the part which deals with that is section 61 to 66 deals with this topic. Just hold on. Sorry. Section 61 to 66 of the Evidence Act deals with this. Anyone having difficulty not hearing? No, my voice is proper. Kundan Matre. I think there might be some issue from your side. I can see on my laptop. So, in the given instance, in the given case, what happens is that original is with the defendant. So, you will have to follow a proper procedure before you are relying upon the copy which you are having. So, there cannot be substitution for original document. एक minute, just let me put it on the chat box. Let me put a link of this thing on the chat box where I will be just you all of you join that this thing. Because Rakesh, I think, is in some difficulty. Let me just copy the link of this. I put a chat link of the where I will be posting the judgments. Can you all join that? Just giving a 1 minute to join that group. If any complaint, let me know because Rakesh had to leave earlier. Are you able to join that group? Yes. Okay. So I don't want to insult someone and all those things. So I have made beforehand itself. Okay. Okay. So I'll be putting the judgment on this. Maybe not this next these things at next Friday. Okay. Now the procedure which has to be followed in this kind of circumstances. First, what you have to do is that properly make it, you have to give a notice to the other side that I desire to produce this document as a original. As a first notice has to be that him asking, calling upon him to produce the original document, because original document is with whom? With the defendant. So you have to first call upon him, ask him that kindly produce that document. In all probability, for our discussion, he is not producing it. In that notice, it is under section 66 of the Evidence Act. In that notice, you will have to specifically say that give time for 7 days, depending upon the things. If you fail to produce this document, original document, I am going to produce this in the court as a secondary evidence. So what is that? First is that no, Manju, photocopy is not original document. It's a secondary document, not a primary evidence. So please bear in mind, original is original unless somewhere wherein there is a letter where the both parties have signed it, then it could be original. Otherwise, no. So you are giving him opportunity to produce that. Because he has failed to produce it, you are producing it. But for that, you will have to take a permission or the leave of the court, stating that original document is with him as required under section 66. I have given him the notice to produce the original document. Since he has failed to produce the original document, I am producing the original document. I am producing the secondary evidence. So you have made a case. You have made a case for production of secondary evidence. So if you follow this process, only then is secondary evidence will be permitted. Otherwise, because original, you have given an opportunity to produce the original and he has not produced, so you are producing it. Then signed acknowledgement can be treated as original or notarized true copy. None of this certified true copy by ACM also, none of these are original document. I will come to that also now. Even I will suggest there could be difference of opinion on that. Even signed document may not be the original document acknowledgement. By giving that document, by producing the acknowledgement, what you are proving is that basically you are proving that you have sent that document or given that acknowledgement. Here is a technical, you try to understand there is two things, different things. One is original document. So you have to prove the original document. And second part, what you have to prove is you have to prove that that original document was given to him. Acknowledgement is what you are proving, second part of it, that this was given to him. So that is what a second, you are proving two things you have to prove. One was that original and original was given to him. So you are giving that. So when we are talking about acknowledgement, acknowledgement will show that this is what was given to him. He has acknowledged it. But original is with him, and proof of original given to him is with you. Sorry. So it's a, for acknowledgement is in your case is a primary evidence, and second part is secondary. Sorry, that document is a photocopy or even copy on which you are taken an acknowledgement is a secondary evidence. So you made out a case, and then in such circumstances, judge will have no choice. Then he will have to produce it. He will have to accept it as an evidence, and it will have to be marked as an exhibit. What is the marking of the exhibit means? Is basically that document is proved. It means document is proved does not mean that contents of the documents are proved. Take extending that, giving, I am extending that example. In that letter which a plaintiff gives to defendant, he says that by such and such, on such and such that you and we executed an agreement, and under the agreement I have given you suppose 20 lakh rupees by such and such check, such and such man. So by that letter, what I am telling him is that two things. For our discussion, I am just pointing out two things. One is that agreement is executed between you and me. Second part is I have paid you 20 lakh rupees. So by following a procedure of proving the letter, did I prove that there was an agreement between plaintiff and defendant and I paid 20 lakh rupees? Is a question for you. My question is, by proving that document, proving that letter, I have proved by secondary evidence by submitting into the court. Does that mean that I have also proved the things which are written in the letter, that there is an agreement between you and me, and under the agreement I have given 20 lakh rupees? So that is my question which I am asking. Good. Appreciate. Chetan, Manju, Leslie, Prajakta. Good. Okay. So basically what I have proven is that when I am talking about this, I have proved a existence of that letter. And this was a simple example which I gave. That agreement was executed and amount was paid. That could be more complicated things also depending upon the circumstances. So by this process, I have proved that there is this thing. I have paid. I have not proved. I have proved the existence of a letter. But then independently, then I will also have to produce the agreement. I will have to prove separately that I paid 20 lakh rupees to the defendant. That will have to, for that purpose, I will have to maybe do the bank statement or something called there is Banker Book Evidence Act, which I'm doubtful today's relevance to on that. But there is called Banker Book on which he gives a put a stamps that this is what, so production of that is to be sufficient. So many of the thought is coming to my now means when I'm talking to you. So just bear with me. Maybe I am not having it right now in my handy. So you will have to prove that